Greetings. This is attorney Della Welch, and we're looking at tape 4, and I'll be emphasizing mainly your closing argument. We have just spent some time going through the important Family Code 4320 and all the many factors. Do not be surprised if you have to take several hours or the other side takes several hours in fleshing out and giving examples pertaining to their case of the various aspects of the marriage. Then after you complete your arguments at the final hearing and both of you rest, so the petitioner starts out and calls their witnesses, and then they rest, and then each witness is cross-examined by the other side, and then the respondent presents his or her witnesses, and each witness is cross-examined. Sometimes there's a need for redirect, and the questioning goes back and forth. But when both parties have rested, then you look at performing a closing argument. Now, both parties need to summarize everything that happened at the trial and not add new information. Be specific and say what you want the court to order on each issue. If you want $400 of spousal support, ask the court for that. And the spousal support would continue until the death of either party or the remarriage of the wife or the husband, depending on who is the supported person. And you may want to ask the court for the parties to work toward co-parenting, because at the end of the hearing, you'll no longer be married, but each of you will be the co-parent of the children, and we want to know that each child is loved. And then each party can recommend the visitation schedule. They might say, I want 5% with this child. I want 30% with the second child. And there may be CCRC recommendations. There is also what is known as the 730 expert instead of CCRC that's making recommendations. If you don't like the 730 expert, you have to look at a 733 expert, and you can research that. I won't be covering that in great detail. But on the support issues, it used to be there'd be little charts. Now there's a little wheel that plots the income and determines the amount of support. What the courts look heavily at, and I would argue this in your closing argument, is, for example, the 2021 W-2, which would give the yearly income, and then I would divide it by 12 to determine the monthly income. Many partners argue that the spouse's support should be zero because, for example, the wife is gainfully employed. However, we need to look at the fact that she may have been out of the job market for 10 or 15 years to care for the children, and therefore, in order to equalize things, she may need 4 more years of spousal support. Also, it's important in your trial to ask who is assisting the wife or the husband in income. Has the wife taken vacations? Who's paying for the vacation? Are they getting food from charity groups and that's impacting their income? Make sure you ask that at the trial, and then what you can do in the closing argument, you can highlight that. So there's another issue, which is a big issue nowadays, of $500 an hour. Attorney fees are a big factor. It's not unusual for parties to have 50, 60, 70,000, 100,000, 200,000 in attorney fees. So you need to make known to the court how much you owe on your attorney fees. And then when you present everything in your closing argument, you may need to bring your paperwork there just in case your memory's not good on your exact amount of attorney fees owed. Then after each party presents their closing argument, then what happens? The judge will take the case under advisement. One of the things that surprised me so much when I first became an attorney is just how many cases a judge may deal with in a day. He may have an hour or two for you, and you may only get a couple hours work done, and then you have to come back on another day. So the judge may have to take another case while the matter is under advisement, and then he will come back and he will state his particular order of child support and spousal support and other issues pertaining to the matter. Then what some judges ask the jurisdictional questions at the beginning of the final trial. Some of the judges ask it as they give their final ruling. But the important judicial questions are, first, have you lived in the state of California at least 6 months, and in the county, such as County of Riverside or Los Angeles or whatever county you're living with, the time of filing, for at least 3 months. And most of you will be saying yes then, because you want your divorce. And then the second question, the judge or the attorney can ask you, have irreconcilable differences occurred that have led to your immediate breakdown of your marriage? And usually you say yes if you want a divorce. And then the judge or the attorney saying, would any further assistance from the court or any parties be helpful to you in saving your marriage? Usually you say no if you want your divorce. And then there'll be an indication of the date that jurisdiction was acquired over the other party. You can obtain that from the court file. And the judge will find that there's sufficient basis that the marriage be terminated. And then he can terminate the marriage right there. Earlier in my practice, you'd have to submit the final paperwork to have the marriage final. But now it's final right there. But it's a good idea to submit the final paperwork because you want to have it for your records. Suppose you want to have a traveling visa or a passport. Sometime you need to have your final divorce information. So you need that for your records. This is often a long, costly process. So good luck to each of you, and hopefully these tips were helpful to you so you can talk it over with your attorney, get the Rutter book at the, it's R-U-T-T-E-R, at the law libraries, or talk with the self-help clinic. This will be the end of our recording.